Good afternoon. We've got a full house today. Welcome. I hereby call this the second meeting of the Interim Joint Committee on Families and Children to order. As a reminder, please silence your cell phone as we have a packed agenda today and we don't want any interruptions. First, this afternoon, we need to Secretary, please call the roll.
Senator Rocky Adams, Senator Chambers Armstrong, Senator Elkins, Senator Girdler, Senator Mays Bledsoe, Senator Meredith, Senator Tishner, Senator Webb, Senator Westerfield, Senator Wise, Representative Baker, Representative Kleins, Representative Decker, Representative Dietz,
Here.
Representative Elliott,
Here.
Representative Fleming, Representative Gooch, Representative Rayburn, Representative Raymond, Representative Riley, Representative Rorks,
Here.
Representative Stalker,
Present.
Representative Wilner,
Here.
Representative Wilson, Co-Chair Carroll,
Here.
Chair Heverin.
Here. Thank you, Mr. Secretary. Now we're going to approve the minutes. We'll need to approve the minutes for the June 19th, 2024 meeting. We got a motion and a second. All in favor, say aye. Any opposed? The minutes from June 19th, 2024 are approved as written. Our first presentation will be an update on the reorganization of the Commonwealth Office of the Ombudsman from the Office of the Auditor of Public Accounts. Auditor Ball, can you please make your way to the testimony table along with any guests? When you get settled, please introduce yourself for the record and you can proceed. Please make sure the green light on your microphone is on.
Thank you, Madam Chair. I am Allison Ball, the Auditor of Public Accounts. I have with me the newly appointed Ombudsman, John Great, to my right, your left. To my left, your right, I have General Counsel for the APA, Alex Magira.
You can proceed.
Thank you very much. So as you just said, this is an update on where we are. We're almost 1 month past the transition point of moving the Office of the Ombudsman from CHFS to under the umbrella of the APA. As you'll recall, just by way of background, just to kind of tell you how we got to where we are, as you'll recall, in 2022, the General Assembly had a CHFS Organizational Structure, Operations, and Administration Task Force. And through that organization, there was a recommendation that the Ombud office be moved out of CHFS and under the umbrella of the APA. And the idea behind that, of course, is it doesn't really make sense for the Ombud to be under CHFS since the Ombud is the one that actually ensures that there's accountability, the public has someone to go to. So there needs to be a little bit of separation for that to work the way that it's supposed to. Senate Bill 48 from 2023 session effectuated this move, and the effective date of that was July 1, 2024, so almost 1 month ago. That actually allowed a lot of transition time to be able to meet, to figure out that we are doing all the things we're supposed to do, getting everything lined up. And I will say, for about 1.5 years, there were those meetings. So those meetings, actually, a lot of them occurred before I got in office. And those were good meetings. Those were positive meetings. Those were helpful meetings. And when I got in office, those positive, good meetings continued. And that is until around April of this year. So shortly after session ended, we had a big meeting with leadership of both CHFS and the APA to figure out, okay, we're almost to the point of transition. What do we need to do just to close all this out and make sure everything's where it should be? And it was in that meeting that we were informed that there was an issue with iTwist. And just to give you kind of some information on what iTwist is, that is the database that contains information regarding child and adult abuse, neglect, and dependency in Kentucky. A handful of other issues are in iTwist. But it's the database that has to be utilized, has always been utilized by the Office of the Ombudsman. If you get a complaint from the public, you have to be able to review what has happened. And this database, as I said, up until July 1, was always available to the staff of the Ombudsman's office. Once we had this April meeting, we were told that it was the Cabinet's position that there was a statute in the area of the law that deals with the juvenile code that they felt like prevented access, despite the statute that governs the transition, which was abundantly clear. Section 102 of Senate Bill 48 said all programmatic staff, personnel, records, files, equipment, resources, funding, and administrative functions shall be transferred. KRS 43035 expressly states that access to all records, it governs all records. It says CHFS shall not willfully restrict access to records or personnel. So those statutes were entirely clear. Those are the statutes that we talked about up to this April meeting. And in this April meeting, the cabinet indicated that they felt like that it was not permissible to have access under this other statute. Before I go into that a little bit more, though, I just wanted to go into a little bit why this is important for iTwist, and then I'm going to discuss some more about that statute. So, like I said, it's child and adult abuse, and much of the discussion to this point has dealt with just child abuse. The statute that the cabinet has relied upon to say that we don't have access to iTwist has to do with the juvenile code, does not have to do with adults. So we have said the adult abuse part, you cannot use that as a reason to prevent access to iTwist. You should just go ahead and give us the adult records. It's not at issue here. And just to kind of give you the importance of that, there's a caregiver misconduct registry, which is updated. So that way, if you have people in nursing homes, etc., this registry indicates if someone has been determined to be a caregiving abuser. So it's supposed to be updated regularly, so you know that your grandparents, your elderly relatives are not being taken care of by someone who is an abuser. It's supposed to be updated regularly. It has not been updated because we have not had access to iTwist. So it has not been updated for the last month. I don't know if that's a problem. It's possible a month has gone by and there have been no issues, but I would doubt that. And those are serious things that need to be remedied and fixed right away. This is not disputed. It's not an issue. And I would say that should be fixed immediately. And we've commented on that, and we've discussed that about saying that needs to be resolved right away. Going back to the child abuse, neglect, and dependency portion, iTwist is necessary because the Ombud does three things. I'm just going to really quickly go through that so that we have a full understanding. One, the Ombudsman Office does self-initiated investigations, both systemic and case by case, and offer suggestions for improvement. So you have complaints that come in, but also you have issues that you're concerned about and you need to look at and see, is this a systemic issue, not just a case individual issue. Also, investigations and resolutions for constituent complaints, both systemic and case by case. So you've got your self-initiated, and then you have some that come to you from constituents. And then also, this is another one that's a little bit different. The Ombudsman packages documents for administrative appeals to be adjudicated by the Attorney General's office. And that's a packaging that is always performed by reviewing iTwist to make sure you have everything that is needed for the appeal to go forward at the AG's office. And as you'll recall, that portion that now goes to the AG's office used to be at CHFS and is now divided up and been sent over to the AG's office. Just by way of completing this discussion, the statute 620.050, which is the one that CHFS relies upon, that says that it's part of the juvenile code, we take the position that that actually grants the Ombudsman access to TWIST because one of the exceptions listed in that is if you are a social services agency. And if you look at case law has a three-part test, which I won't bore you by going into, but we think it is a very, very strong argument that the Ombudsman Office meets that. So even if you say that statute applies, which we don't believe that it does, but even if it does, there's an exception under that statute. I know this isn't a court of law, so you may not want to go into all those arguments, but I just wanted to give you kind of an understanding of what it is that's at issue right now. This is also significant that I think this body needs to know. Federal law has very clear language that says in order to be able to be eligible to receive federal grants, that there has to be compliance for investigations and cooperation among agencies. So it describes the kind of cooperation that would exist between the Ombudsman and the Cabinet for Health and Family Services if we were to have access to iTwist. If you don't have that access, if someone is preventing us to be able to see iTwist, then that actually is no longer compliant with federal law, and I do believe puts federal grant money at risk, which could be a very serious issue. So I say this because it's not just about the public getting the redress it needs, getting the access that it needs, but there's also federal dollars at play. that is probably most of what you need to know. I think it is worthwhile that sponsors of the bill have made it clear. We had a discussion with them on June 6th. All of us were together on June 6th. And Speaker Pro Tem Meade, Senator Meredith, said clearly, and I know Senator Meredith has also said this to the media, that it was the clear intent of Senate Bill 48 that the Ombudsman Office have full, direct, and real-time iTwist access. And even the governor, when he discussed this, said that it is necessary for the Office of the Ombudsman to be able to carry out its duties for us to have iTwist access. So I don't think that there's any issue about, any disagreement about whether or not we need the access. It's totally clear we need the access. But right now we're being prevented from having access. At some point within the last month, there was some suggestion that we could see things if we provided names, social security numbers, and dates of birth for individuals who wanted documents, and it would be case by case. This has never been required before. It's not in the documents that are filed to be able to see things. This is a brand new requirement, and it's just not always available. We don't always have all that information to be able to see it on a case by case basis. So it's not workable. In addition, there's problems with doing it that way. It causes delay in processing administrative appeals. We're unable to determine if CHFS has actually given all the information. It undermines investigations for that reason. It reintroduces a conflict of interest that the General Assembly was trying to avoid because, again, you're having CHFS being very directly involved in the investigation. You may need additional documents that are just not caught with that kind of search term. And this is significant. It also unmasks whistleblowers. You really do need to have a certain amount of confidentiality in order to be able to look into things. So if it's somebody within the cabinet who comes forward, there could be a retaliatory action against that person, and it further complicates the process, and that's one of the reasons why it was removed from CHFS to begin with. And it does have a chilling effect, I do believe. So we have attempted to kind of go through that process for the last little bit, and CHFS has been slow and unresponsive. We usually have to make 2 or 3 requests for a document. We routinely receive hundreds of pages of document that are not relevant, and we have to sort through those. And the Ombuds staff have told us, the ones who now work for us, that they have been having to tell the staffers over at CHFS how to get certain screens to come up and how to get certain documents to come up, which would, of course, be avoided if we could have direct access. That was early on when we were trying to figure out how to reach a resolution on this. 2 weeks after the June 6th meeting, we elevated this issue to the governor, to his GC, and then his chief of staff. Chief of staff never responded to us. The GC said, it looks like there's a difference of statutory interpretation here. That's all we got at that point in time. So then we issued some demand letters saying this needs to be resolved. That was shortly after, a little over a week after the transition period of July 1. It's gotten a little bit of media attention, which I'm sure you all have seen. And after all of that, we had pretty much silence for a while from CHFS until last Friday. Last Friday, we got an email, something like 2:30 in the afternoon, from General Counsel over CHFS indicating they would like to revisit this. It's possible we may be able to work out agreement. We would love to work out agreement. It would be great to work out agreement. We want the public to have access. We want to be able to do our job. We would love to do something that would give an agreement. Up to this point, we had... we got an email on Friday, and I think probably they had to run things up the chain, perhaps as high to the governor, I don't know. So I think it probably was difficult given his schedule over the weekend to get a hold of him. So Monday we got a message back with it. We sent over a proposal on Friday. We got a different proposal from them on yesterday, and we have not been able to reach an agreement. I was really, really hopeful. I thought this is great. I'll be able to come to you all and tell you we reached an agreement, and we can all go our merry way and be happy about this resolution. But as of right now, we don't have an agreement. And it seems that the sticking point is in order to be able to have access, CHFS has, up to this point, and perhaps it'll change. I'd love it if they change. It'd be great if they would, has wanted us to agree that their reasoning is correct. And as long as we agree the reasoning is correct, then they'll give us certain defined access. And that is not a workable position because we have to be able to have access to the courts if we need to. If we agree that they're correct, then all of a sudden they can set the terms, and it's not worked very well up to this point. I would love to say that I have great confidence that we can all reach an agreement and go our merry ways and be happy, but the language is important in this, and I think the language needs to be, we don't have to say who's right or who's wrong. And I would just say, Everybody can maintain their positions. They can maintain their position. We can maintain our position. We don't have to have an agreement on what that is. We really don't. But we could just have an agreement going forward that we can have access. And I think there's a way to draft that. So that concludes my remarks. I think that's a full update. I don't know if the gentlemen on either side of me have anything they want to add to that. But that's a full update from my end.
Thank you, Auditor Ball. We greatly appreciate it. We're going to start with questions, and I think that Senator Meredith is the first one on the list.
Thank you, Madam Chair, and thank you, Auditor Ball. Would note that as we were pursuing this legislation, I contacted then Secretary Ball to tell her what we were thinking, because I knew she'd be running for this office. If that's something that would work under this auditor's office, and she was quite excited about the prospects of doing that. And I think it makes great sense in terms of transparency and accountability and eliminating conflict with interest within that cabinet. This came out of our task force for the reorganization of the Cabinet for Health and Family Services, which I co-chair with Representative Meade. And we purposely gave this a long timeline to give everyone plenty of time to work out the details. And obviously the biggest sticking point is this I-twist. And it's just very disappointing to me that we didn't address this at the get-go, since that was the biggest obstacle. And that we still haven't come to terms with this. Quite truthfully, I'm quite embarrassed that you have to be here today and that we have to do this, because we will do this. If it requires legislation in 2025, we'll do that with an emergency order, but it's a shame. It doesn't serve the best interests of our children to put this off for 7 more months, but it can be fixed. So we've got a situation, either the cabinet won't share the data or can't share the data. Well, my position is that if their position is they can't, there's an avenue to address that. Because in KRS 620.050, it says that the report of suspected child abuse, neglect, dependency, and all information obtained by the cabinet or its delegated representative. So my interpretation of that is they can provide you with that just by agreement that you are the delegated representative. If people have problems with that wording or that particular issue, you can go further in the statute, and it says that it can be provided to those persons authorized by court order, which means if there's an agreed order from the cabinet to allow you folks to have that data, we can do so. So the fixes are there. They should be very simple, very straightforward, and I don't understand why we're not doing that. If we don't take either one of those approaches, then it's just, we just won't share the data, and I don't understand why the cabinet want to operate in that kind of secrecy and direct animosity towards the legislation that we think is going to benefit everyone. But those two things I mentioned, do you see those as viable paths forward to get this thing resolved?
Senator, I really do believe that the General Assembly did everything correctly. I don't think that the issues that have been raised regarding 620.050 are a barrier. I really don't believe that they're a barrier. I think the arguments are extremely clear, and I'm more than comfortable making them before a court because I believe that they are 100% correct. So I don't believe the General Assembly actually has more work to do. That being the case, if the General Assembly felt like it wanted to make it abundantly clear and make it a full stamp of approval, that's certainly within the purview of this General Assembly. But I don't believe that it is necessary. I believe that you did everything that you effectuated everything that you wanted to do correctly.
Well, like you, if we had to file the legislation in 2025, I looked at that as a last effort to try to get this thing resolved. We shouldn't have to go to that point. I mean, after all, we're on the same team here. We should be trying to resolve the same issue. So again, it boils down to whether we can't share this data or we won't share that data. Well, you can, because here's the two vehicles you could do it. If you don't want to embrace those, then you just don't want to share the data. And unfortunately, and I got great respect for Secretary Freelander, but historically that cabinet has an issue with operating in secrecy, and we need to move off of that. That's one of the reasons we moved the office from the cabinet to you folks. So I think there are paths forward there, and I really wish we'd pursue this and get this done. Thank you, Madam Chair.
Representative Raymond.
Thank you. I guess I want to ask what an agreement could or should look like. Isn't there a history in state government of MOUs between divisions or departments where you could get the necessary information but still ensure protections for personal confidential data. So have you breached the idea of an MOU with the governor's office? What agreement have you all proposed, and what do you think it should look like?
Thank you. That's a wonderful question. So what you're describing is a memorandum of agreement, and there is a longstanding practice of doing that. We would be happy to enter into something like that with the cabinet. And actually, Amy Bensonhaber did an op-ed last Thursday, I think, and she essentially proposed doing that as well. So this is something that we're hearing from the public, as well as something that we would be comfortable with, as well as from you yourself. That is something that I do think is a more than acceptable approach. The one thing I think is important in the language of it is that it is simple. It clearly says direct full access, and I think that it is important not to cite legal positions in it, because we feel like at this point we don't want to preclude ourselves from remedy if we ever needed to seek it. And you know, I am a lawyer, so I always think in terms of make sure you don't close yourself from access to the courts if you ever need it. That's just sort of my training in nature. But I actually feel like because of where we've gotten to at this point, it is necessary not to preclude any avenues going forward. I would love to enter an agreement. I think we could. I really do think we could. But I think probably everybody needs to say, hey, well, I don't need to say you're right. You don't need to say I'm right. We really don't need to get into this. Let's just say, you know, notwithstanding difference of opinions, notwithstanding different legal interpretations, we have agreed to move forward going this way. And I think that's a meet in the middle solution.
Thank you. Representative Dietz.
Yes, thank you. Did the cabinet share any concerns, or are you aware that they shared any concerns with any members in the General Assembly during our last session?
It did not come up until after session.
Okay, thank you.
Does anyone have any further questions for our auditor? Speaker Pro Tem Mead.
I don't really have anything for the auditor, but I would, could the secretary come up and
Absolutely. Secretary Friedlander and Wesley. And just a reminder, if we've never met you before. Can you please introduce yourself for the record? Make sure your microphone's on.
Eric Friedlander, Secretary of the Cabinet for Health and Family Services.
Yeah, Wesley Duke, General Counsel for the Cabinet for Health and Family Services.
Thank you.
Thank you, Madam Chair. Thank you all for coming this morning or this afternoon. And I had as Senator Meredith mentioned in the bill, and in several other areas of statute, it says that there can be an agreement with a court order if that is not in statute. With that said, would the cabinet be willing, if we could get a agreed upon court order, would they be willing to honor that so that we could transfer twist to the auditor's office?
As far as an agreed upon court order, at this time I can't commit to that, Representative Meade, and I apologize. I just at this moment I can't answer yes or no to that question. I apologize.
Okay.
However, we are open to an agreement. There's been some back and forth. We feel like we've said you don't need to give up your rights in court, but understanding we're still in the process of working, and we will continue to work.
Under the legal and the fiduciary duties of the Ombudsman, confidentiality in records has to remain confidential. It doesn't matter where that Ombudsman is housed, whether that's with you all or with the auditor. They have to remain confidential, as just kind of addressing a statement that was made just a few minutes ago. But sometimes to us in the General Assembly, it appears that the cabinets and the departments will pick and choose what they want to honor in legislation, and also they will interpret it the way they want it to be intended. Legislative intent is a funny thing, and that's been brought up several times in our meetings and then a little bit today. I can tell you that the legislative intent on this bill, because this was my language, was that all of that transferred to the Ombudsman's office. The iTwist program is the way that we pull back the curtain and see the issues. The Ombudsman just simply cannot do his job without full access to the TWIST program. So, as Senator Meredith has already alluded to, I ask that you continue to work on a resolution for this, and you all have told me that you will, and I appreciate that, but I ask that you continue to do that, because if it's not resolved, I can guarantee you that we will come back in very early in the next year's session and fix the issue. So thank you all.
Yeah. We understand that. And to Senator Meredith, I want to say Senate Bill 48 was a big bill. Transfer of disability determinations, transfer of the Office of Children with Special Health Care Needs, transition of hearings to the Attorney General's office. I think I'm missing one. Guardianship to DCBS. Everything has been done and completed. We have one issue, and this is where we have a disagreement. But we will continue to try to work through it. And you all have made very clear that if it does not get resolved by 2025, you will be back and you will resolve it. I do understand that.
And if I can add one thing to that, just some background. The first time an MOU was broached was July 1, and it was summarily rejected by the APA. And then I did come back on Friday and broach the issue again, which led to this current back and forth, which I think has been fairly productive, honestly. I think we've gotten to a point. But I made it very clear to the Auditors General Counsel on Friday that by agreeing to this, they would no way be closing themselves off to any avenue through any court to seek any relief they thought necessary, any legislative action. By taking these steps, they did not do that. So we made that very clear. We just want to get from today to, once again, I do think legislative action is the cleanest way to solve all this. But we just want this stopgap that protects these records. We comply with our statutes, they comply with theirs, and they do their business. So I agree with you, Representative Meade. The Ombudsman can't operate fully without this access, which they always had by virtue of being in the cabinet. So that's where we are here today. But we're not trying to shut off their avenue to any court.
And I hope you all, if you didn't hear that in our communication, we're now on record for that.
Thank you. I'm actually going to send it back to Representative Dietz if you'd like to ask your question.
I think it's the same question I had for Auditor Ball. Did you voice any of these concerns during the legislative session while we were working on this?
So, no, there's the answer. And I will tell you, as we have gone through, working through Senate Bill 48 and looking at all of the multiple systems as we went through, this really did come up late in the analysis. We've had some things with every piece that we have transitioned. There are pieces that come up that we didn't expect. I will tell you, this is one of them. And it is, I will agree with everybody here. It is an unfortunate one. But as we looked through, and we had to go through each individual system, and there are many, this was the one that came up and caused the biggest issue, again, because we saw a statute that absolutely concerned us.
One follow-up.
Yes.
Do you believe that the transfer of the Ombudsman has increased the public's confidence in the cabinet at this point?
I don't know the answer to that question.
Okay, thank you.
Senator Elkins.
Thank you, Madam Chair. Representative Dietz really hit on the question I had, but I'd like to drill down into it just a little bit further. I have to think that it would have been early on that you would have identified that you felt KRS 620.050 precluded or prevents you from sharing iTwist. It just doesn't seem like that would have been something that came up last month. I have to think that this was identified prior to or during the 24 session. So I'd like to get a better understanding of when it was that it was decided that this would not allow you to share iTwist with the Ombudsman's office.
I'll try to get back to you with the date. It was when I was sitting down with my staff and we really went through each individual system. That's Connect, it's a whole bunch of different systems, public health systems. And when we got to this system, and again, I'd be happy to provide you with a list. It's when it came up. I'm happy to provide that information.
Follow up, please. The other question, or a second question, I guess you would say, more than a follow up. Have you examined other statutes or KRS 61-878, more specifically paragraph 5, that says, and I quote, "The provisions of this section shall in no way prohibit or limit the exchange of public records or limit the sharing of information between public agencies when the exchange is serving a legitimate governmental need or is necessary in the performance of a legislative government function.
And I am familiar with that statute, and I think that outlines our issue here. That's a very, in my opinion, a broad statute. 620.050 Section 5 is a narrow statute. It lists out the number of people who can have, the groups of people who have access to these records. And in my opinion, this is the whole issue. That specific statute controls, and once again, legislative intent is a funny thing, and courts interpret it, and there's an analysis that has to be done. But in that case, I would think, once again, the more specific statute related to twist data would control over that, because it sets out specific groups. And so it's once again, it's a lot, statutory construction, legislative intent, and that's our position. We think that we have to comply with 620 as the more specific statute.
And I'll add something to that. Within the Cabinet for Health and Family Services, even between departments in CHFS, we have business agreements in place that really outlines the exchange of information, even between departments in the Cabinet for Health and Family Services. So while the language of that statute is broad, we still back that up with agreements among our own departments.
And also, as like we said, Senate Bill 48 was a big transition. Ombudsman was a big transition. And I believe we've worked well with them outside of this one issue in regard to helping them work with the Social Security Administration, having access to those records, helping them work with IRS to get those agreements in place, putting them in contact with the right people in those federal agencies. As far as funding, I mean, there are a whole lot of places where we've worked well and worked well together. This is just obviously a big issue where we have a difference of opinion, but I do think there is a way forward with a properly constructed MOU that fills that, 5 months gap to for them to do their job until y'all can obviously take up the issue of the statute.
But an MOU is more policy than statute. Is that not correct? I mean, you would request an MOU as a matter of policy and not statute. And I apologize for the follow-up question,
No.
Madam Chair.
You want to take that one?
Thank you.
Yeah.
Thank you. And we will have one final question from Representative Wilson.
Well, I think Senator Elkins touched on this, but the cabinet believes that this promotes governmental agencies sharing information and records for legitimate purpose, right? Like child and adult protection. That is a legitimate purpose, as he mentioned in the statute.
Well, and obviously that statute that was referred to is that's in the open records context. There's just so many layers of confidentiality and things that have to be considered when any open records request is reviewed, and exceptions, and obviously other statutes like 620.050. And so once again, I think that falls in that open records area realm, but we have this specific statute to this specific group of records that we have to rely upon.
Follow up quickly.
Yes.
But does the cabinet believe child and adult protection is a legitimate purpose?
Oh, absolutely. That's every day. That's our main mission.
Thank you. And I will let Co-Chair Carroll finish this off.
Thank you, Madam Chair. Mr. Duke, help me understand. You said that there should be a way to work this out through an MOU. What is it exactly that the cabinet needs in this MOU to satisfy your concerns?
We proposed in our drafts that we've sent to the APA that we have specific references in the agreement that they will comply with 620.050 and only release records to the categories of individuals that fall within the statute. I realize they think, and I know their legal argument. By agreeing to that, that's to me that and I made it clear to them that's not foreclosing any path to a court. We just need that assurance. And there's a second layer here. We are under federal obligation by receiving federal funds to make sure our records are kept confidential. And I know I said this in the meeting that we had on June 6th. We have to make sure that we maintain the integrity of that and not jeopardize those funds. But if we could get those assurances in the way that we've sent over to them, and we're willing to keep talking, but we have to have that. And that keeps everybody protected until a statutory change can be made, which we would support. And I think we were on record of saying that.
Would not that responsibility to keep it confidential transfer since the legislature transferred that responsibility to the auditor's office?
Yes, I think that if they are able to gain access to these records, that responsibility would fall upon
Okay,
them.
so
If they would acknowledge that.
Okay. Okay. So the restrictions that you all are wanting to place, and I didn't get this straight, how would this limit the functioning of the Ombudsman not having access to all of the records that the current, before it was transferred, that they would have had?
Yeah. So previously, the employees of the Ombudsman at the cabinet, they had their own individual logins to the system. They received a complaint. They would be able to go in there real time, read only access. They could never edit the system. It was only just, like I said, read only access, and pull what records that they felt were necessary for the investigation or follow up on the complaint. If we can work out an MOU with them, we could set that system up again just like that, read only access like they had previously, where they could go in and get that. If they, like I said, if we could get this MOU hammered out, we are prepared to do that.
Thank you.
Thank you all. I will let you all go back, and then we will call you all back up when it's time for you all to testify. Auditor Ball, I just want to invite you back for the table if you have any closing remarks.
First of all, I'm glad to hear that they're interested in MOA. We've wanted to do that for the last little bit. That's great. Of course, saying that you want to do it and then entering into it is always the real challenge. So, we've heard some things today that are encouraging, and I hope we really can work something out. I do think there are some true sticking points that you don't always get into until you actually get to the details. But one of it is that interpretation of the juvenile code. Their position has been somewhat inconsistent by saying, okay, well, we believe this bars you from having access. However, we'll let you have access even now in certain circumstances. So that makes it a little bit, it makes it seem like their argument is a little bit unusual. So with that, we're just going to have to figure out a way to move forward if we can without making commitments about that particular statute. Of course, we're going to comply with the law. Of course, we're going to keep confidentiality. We believe in that. Our goal is making sure the public is served, vulnerable communities are served, children are served, the elderly who are in positions of being possibly abused, these people are protected. So that is our goal. I believe them when they say that they want to do that too. That should give us the point where we both can reach some kind of agreement. I will just say that we continue to get complaints every day from the public, and it needs to be resolved very, very quickly. We've had almost a month of providing almost no services to these people who are being impacted by this. And just by way of like a final concluding thought on this, one reason why I'm very, very careful about this is because we did give up one thing towards the end of our discussions. So they did bring up Twist in April, but they also brought up the phone number. And we agreed to give up that and let them shift through what should be sent to us. And in June, there were 348 complaints received by the Ombudsman's office. In July, it's 105. Last year in July, there were 439. This gives me reason to be very, very, very careful proceeding going forward to make sure that I'm not just taking people's words for it, but I'm making sure that if we ever have to go to the court, they're not wrong to saying we're not precluded from going to court. That's correct. We can still go to court, but we don't want our arguments taken away from us. If we agree that they're right, then that puts us in a difficult position going forward. So I think that concludes my thoughts on it. My general counsel may have something to add to what that I've just said as kind of fleshing that out. But
Thank you, Honorable. Madam Chair, I'm going to be very cognizant of your time because I know you have a lot to get to. So call the clock on me if necessary. So this body did everything absolutely correctly. The language of Senate Bill 48 is entirely clear. Section 102 of Senate Bill 48 is perfectly clear. Everything that existed in the Ombuds office comes with it in the transition. That's one. Section 43.0351 says that CHFS should not willfully obstruct access to records. That's pretty clear. There are about 6 different statutory canons of construction that if you apply them pretty rudimentally, you get to the conclusion that KRS 620.0505 operates as no barrier whatsoever to our access to iTwist. We have made these positions very clear with the cabinet. For the most part, they have not responded to our statutory arguments. Paramount statutory argument is you effectuated the intent of the legislature. We all know that. That is the first and foremost thing that courts look at when they view statutes and how to read them. Right here, the intent of the legislature is to have us have iTwist access. It's pretty clear. You look at the plain language of Section 102 Senate Bill 48 and KRS 43.0351. You don't frustrate the intent of the legislature. That's another statutory canon of construction. The Office of the Ombudsman cannot do its job without iTwist access. Those 3 functions that Auditor Ball was talking about, systematic investigations, we can't access the data we need to do those. We can't even do it on a case-by-case individual basis because we need to know, according to the cabinet, the personally identifiable information of the complainant that has asked us to look into their issue. A lot of times we don't know that, and the cabinet doesn't ask that information of the individual. And packaging administrative appeals. We have had unnecessary delays in doing that and getting people the redress they need. There are other canons of construction. You don't violate federal law. You don't read statutes to violate federal law. 42 U.S.C. Section 5106A pretty clearly states that in order to get federal funding, Kentucky, in a plan signed by the governor, has to agree that they are going to share information among agencies. You can look at subsection B2B9 and B2B11 to look at that. The Kentucky Supreme Court in 2015 in a case called Council on Developmental Disabilities versus the Cabinet. The site is, I believe, 479, I got it somewhere here, 473 Southwest 3rd, 597, laid out a 3-part test for government agencies to get access to data. You have to be a government entity, you have to perform services at the behest of society, and you have to need the information to do your job. That's the 3-part test. The Supreme Court laid that out pretty clearly. The Ombudsman Office absolutely falls within that 3-part test. Most of these arguments have not been responded to because the argument has been that 620.0505 is the more specific statute. First of all those canons I just mentioned trump that canon. Second of all, the more specific statute in this case is Senate Bill 48. The situation that frames the use of that canon of construction is the situation that we're dealing with right now. What does the Ombudsman's office get access to? That is directly addressed by Senate Bill 48. 620.050 is a general statute that generally outlines stuff. 48 is the one that directly addresses what the Ombuds statute gets. There's also the canon of construction that says, to the extent 2 statutes conflict, which we believe they don't, the later statute and time controls. That is Senate Bill 48. So we've made all these points very clear. I'm not really sure what the problem is. When we talked about, and the last point I'll make is Auditor Ball's point about the waiver. KRS 620.0505 is pretty clear. You don't get access to data under that statute unless you fall within one of the exceptions. Now, we think we fall under, first of all, we don't think the statute applies. Secondly, we think that we're a social services agency pretty easily. But the point is that the cabinet has agreed that they are willing to share with us some iTwist data according to the constraints that they put on it. That own interpretation violates their reading of KRS 620.0505 if you take their interpretation. That statute is black and white. Either you get data or you don't get data. There's no gray area. So if we get some of the data according to their own interpretation, like they've allowed us to, they're violating their own statute. That's why we know at the end of the day, 620.0505 has nothing to do with this situation. It is not applicable here, and the General Assembly did everything right. That's all I have to say, Madam Chair. Thank you.
Thank you very much. We appreciate it, and we will continue this conversation.
Thank you, Madam Chair.
Thank you. We're going to go just a little bit out of order. I know that as the time gets closer to 2 o'clock that members will have to leave. And so I want to go ahead and bring up Andrea Day for the Child Care and Development Fund State Plan public hearing for fiscal year 2025 to 2027. Andrea, do you please introduce yourself for the record?
Andrea Day, Director for the Division of Child Care.
Thank you. Is there anything that you need to update us on that you would like to share with the committee before we vote to make a motion to vote to approve the state plan?
No, the only update I have is the Office of Child Care did simplify the state plan process. I don't know if you've all read the state plan. The last one for 3 years was 379 pages. This year it's much shorter and it's much more direct. It's 202 pages. And that is really OCC's focus on us demonstrating and providing evidence to how we are fulfilling the rules under CCDF.
Are there any questions for Andrea? Okay, can I get a motion to approve the Child Care Development Fund state plan? Second. There's a motion and a second. DJ, please call the roll.
Senator Adams, Senator Chambers Armstrong, Senator Elkins, Senator Girdler, Senator Mays Bledsoe, Senator Meredith, Senator Tishner, Senator Webb, Senator Westerfield, Senator Wise, Representative Baker, Representative Kleins,
Yes.
Representative Decker, Representative Dietz, Representative Elliott, Representative Fleming, Representative Gooch, Representative Rayburn, Representative Raymond, Representative Riley, Representative Rourks,
Yes.
Representative Stalker,
Yes.
Representative Wilner, Representative Wilson, Co-Chair Carroll,
Aye.
Chair Heverin.
Aye. It passes with favorable expression.
Thank you.
You're welcome. All right, next up we're going to go back on the agenda to implementation updates on House Bill 71 and Senate Bill 151 from the 2024 regular session. Secretary Friedlander and Wesley Duke, if you can please make your way back to the table.
Eric Friedlander, Secretary of the Cabinet for Health and Family Services.
Hi, Wesley Duke, General Counsel, Cabinet for Health and Family Services.
Thank you. Welcome back to the table. I'll let you all continue. Or I guess I'll let you all start on the implementation updates regarding Senate Bill 151 and House Bill 271.
Sure. Our issue is not a policy issue. We believe in the desired policy goals expressed in House Bill 151 and 271. House Bill 151 does require an appropriation. We feel that we need an appropriation in order to implement. House Bill 271, again, we agree with the policy goals of House Bill 271. We feel we need an appropriation in order to properly implement. We have implemented some portions of 271, working on those that we don't feel have any or no cost to them. And with 271, the concern is, as you all have seen, we supply monthly social work figures, how we have been filling social work positions. We've reduced some of our caseloads. If we implemented without funding for additional social workers, we would increase their workload when we've been making really good progress. And so, again, fully support the goals of 151. Believe the timeframes that are outlined there. are proper and good policy, but we feel we must have an appropriation in order to implement.
Thank you. I'm going to let my colleagues ask a few questions, and then we will follow up. I'll wrap it up for us. Senator Julie Rocky Adams.
Thank you, Madam Chair. And, you know, I was frustrated last month at this committee meeting. And I know that you believe that you need an appropriation to proceed with the implementation of this. The statute reads that you needed to come up with administrative regulations on this bill. Have you proceeded on the administrative regulation portion of this bill?
We have drafted administrative regulations. We don't feel we can implement them without an appropriation.
Have you also proceeded forward on pursuing the waiver with the federal government?
Without an appropriation, we don't feel we can proceed.
Okay, and Madam Chair, can I follow up on that appropriation issue?
Yes, Senator Rocky Adams, I'm going to give you permission. I usually like 4 members to bring it back to me, but I'm going to let you be able just to ask the questions that you need to, since you were the bill sponsor for this.
Thanks. And on the issue of the appropriation, are there programs within the cabinet that are not line itemed within the state budget?
There are many appropriations that have been within the Cabinet for Health and Family Services budget, particularly those that are ongoing across biennia. So those do exist within the cabinet.
And are there programs within DCBS codified in state statute like the provisions of Senate Bill 151?
I'm not sure I'm following your question.
My point is I believe that the cabinet funds programs that are not codified in state law. I believe I'm 100% correct in saying that. I believe that DCBS funds programs that are not codified in state law. This 151 is codified. So the thought is, how can you fund things that are not line itemed in the state budget and then claim you can't do this because it's not line itemed in the state budget?
This is a specific program and a specific piece of legislation that has a cost associated with it. We communicated that on multiple occasions, and we believe that there is an applicable Supreme Court ruling that supports that.
Okay, and then to follow up that, well, the applicable Supreme Court ruling is not correct, because you cannot claim that the state legislature didn't fund this program based upon that Supreme Court ruling, because the legislature didn't pass an executive branch budget, and we passed an executive branch budget this last time. So I think that is kind of a red herring, and so I'm going to go back. How do you know the specific price tag of this program if you haven't drafted the regulations?
We provided an estimate, as we do on every piece of legislation, and we send it over to the Legislative Research Commission in the budget. Have done it. I've been here around a long time. We do that for every piece of legislation, and we make our best estimate.
And you also understand that the comment that you made about social workers increasing the cost because of social workers, we did increase the social worker budget in this past budget that we passed.
This is a specific program that has a cost. It needs to be funded.
Thank you, Madam Chair. I would like to follow up later on.
Speaker Pro Tem Mead.
Thank you, Madam Chairman. Secretary, I understand where you stand, and we've heard this for the last 4 years. I have served under 3 different governors. I remember us passing legislation on programs, on a lot of bills that had appropriations on it, that we did not line item things, and those governors never used this excuse that it was not appropriated. This is just another example of the executive branch picking and choosing what they want to do. And I'm not laying that on you because I think this actually goes above you, Secretary. The cabinet came back. I was in some meetings. The cabinet came back, and there was concerns about the appropriations back during session, and we all thought that was addressed by the time that we passed the bill. But this governor continues to refer to Fletcher versus Commonwealth, which is what you were talking about, and Senator Adams kind of alluded to it. But in that Supreme Court ruling and that opinion, it said that was when this General Assembly left with no budget, passing no executive branch budget. It said in there because Fletcher at the time was then appropriating his money the way he wanted to, and that's when they said that you cannot do that unless it's appropriated by the General Assembly. But in that opinion, the part that you all continue to leave out is that there is an opinion in there that says that when they do pass it, it is the responsibility of the executive branch to implement these programs to the best of their ability, not to ignore them. And that's what this governor has done. For the last 4 years, that's what he's continued to do. Leaving with no budget is totally different than us budgeting something. And when we don't line item something in the budget, that's because we believe there's enough money appropriated in your budget for you to do it. That's what we believe. That's what happens when the General Assembly budgets. That's what happens in every other department, in every other cabinet. But when it comes to what the governor doesn't want to do over the last 4 years, he then uses this specific case to say, oh, I don't have to do it because you didn't appropriate money. This is funding that we were talking about for kinship care. Some of our most needy families in this state. These are political games that have been played for the last 4 years, and it infuriates me that he continues to play them right now with these most needy families.
Thank you, Speaker Pro Tem. Representative Rorks.
Thank you, Madam Chair. So, as you know, with House Bill 271, that was a bill that I was a co-sponsor on and obviously contained many parts. I'm wondering if you can share with us which parts of the legislation that we're on track to be implementing and which ones, because of the lack of funding, are not going to be implemented. And just for the committee, I did pull up the bill while we were listening to the speakers, and I know that there are several reporting mechanisms that will go online as of August 2024 and an annual report starting in December. So I would also more specifically like to hear if we're going to continue to get those updated data metrics.
Yes. If I may, I'd like to phone a friend who happens to be here. Commissioner Dennis will be able to give you an update on that.
Thank you.
Commissioner, when you get seated and settled, please make sure to introduce yourself for the record.
Good afternoon. Lisa Dennis, the Commissioner for the Department for Community-Based Services. With regards to 271 and what we, can you hear? Sorry. With regards to what has been, what we're either has been implemented or we are in progress of implementing, it is, again, all pieces except for the pieces that require additional funding, which is around Section 6 of that bill, has either been implemented or is in progress of being implemented. And the data pieces for August are already available. We are making system changes that are currently on track for the December, to begin the reporting in December. The system changes will just be in place at that time, so there will be some limited data for that first report, but they are in progress.
You can have a follow-up.
Thank you. I also wanted to ask more specifically about, obviously, House Bill 271 started as a cleanup bill to adjust for the piece around teachers reporting so that they could give additional reporting in other avenues other than written. So is that also on track to be implemented?
Yes, that's always been available. It was just making it clear in the with the cleanup language. But yes.
Thank you.
You're welcome.
Thank you. Representative Dietz.
Yes, thank you, Madam Chair. I also worked on this bill, and we spent, a lot of time together working on this. So my question's the same. It was a bipartisan bill. What parts can't we implement? What part are you saying requires more money?
primarily it's those pieces that would increase, we think dramatically increase the number of investigations that we need to complete.
May I follow up? Can you be more specific and tell me where you think? What we did is we tried to, this is important. We're talking about saving children's lives. We heard from many family court judges across the state, and I heard from my family court judge just last week that there's still an underreporting going on because of the pathways that we're using. So can you be more specific and tell me where and how much money this is going to cost? This is kids' lives.
As I started out, we do not have a policy disagreement. What we have is a funding disagreement. And that is true. And so where we see a need for increased number of social workers to make this bill, and we said Section 6, they've been a part of the fiscal note. They're a part of the fiscal note that we provided to the legislative budget staff. We've lined out exactly where and what we think those increased costs would be and where they are.
Can I have just one more? And I want to make just an observation from my day job, which I shared with Commissioner Dennis. I think you were there the other day, and I made the observation. I don't go to DNA court very often, but recently I've been in dependency, neglect, and abuse court on a private case. And I sat there on a Friday, and I looked to my left where the social workers were sitting. And this is not against the social workers. This is more about management. These were case management. They were 5 minutes, but we had at least 30 social workers sitting in the courtroom waiting for their case to be called. One was sitting there with her knitting bag knitting because the docket was running so far behind. When we say that we need more social workers, can we not manage their time better by not having 30 social workers sitting in a courtroom waiting for their case to be called for case management?
I'm happy to try to take it, but basically, if our social workers are not in the courtroom, the judge can find them in the contempt, and we have had that happen to us and to them.
Thank you. I'm going to chime in with a few questions. First off, were there any general funds that were not used by DCBS at the end of the last fiscal year? And this is for you, Secretary.
I think the main portion of general funds had to do with child care piece that was for the businesses that wanted to participate in child care. Some of those funds, and I can't tell you the exact number, but I'm happy to get you that. Some of those funds indeed went back to the general fund.
So I'm under the impression that according to EMARS, which for those that are just watching online is the state accounting system, that specifically DCBS lapsed over $14 million in general funds at the end of the fiscal year 24. It's also worth noting that DCBS is the only agency within CHFS that lapsed general fund dollars. Have you all had, in regards to House Bill 271 that we all worked on, and I know this is, for those watching, we're both talking about 151, 271, Senate Bill 151, House Bill 271, but they're both issues with funding. And so my questions are really relative to both of those because they are funding questions. But specifically to 271, how much does it cost for a social worker in Kentucky?
About 80, 90.
Because I'm trying to add up
about 90.
how the request from, and I just read it, I think the newspaper's in my office, that you all are saying that you all can't fund House Bill 271 because you are short $43 million. So of that $43 million, what is the cost of a social worker?
About 90,000, somewhere in there. That's a guesstimate on my part. I do want to go back to the lapse. Again, that's a mandated lapse from budget language from the General Assembly, and I'm very confident that I know exactly where that's from.
So, how did you all in September, I believe it was September, December, you all had money left over for child care subsidies with the cabinet. How were you all able to find that money?
That funding came from initiatives within the child care portion, where we were able to get child care, and I think we would have had a much more difficult time to get child care to the point where we could provide an additional subsidy payment. We have since made that payment with federal funds that we had.
I think from my perspective, it makes it look like the cabinet is picking and choosing what's important to them. So it seemed like last year it was child care, but you were able to find the $30 to $40 million and able to pay subsidies, which was not a General Assembly requirement. That's something you all chose on your own, even though it was from federal funds. And so now we're at the issue where we need money for kinship care and for CPS, DCBS for House Bill 271, and it's not there. How many kids do you all have in kinship care? Or who would be eligible even for kinship care?
We have approximately 1,500 children that are in relative or restricted care currently within our care.
Thank you. So I think it's very interesting. Senator Rocky Adams brought up federal funding portion. Have you all worked with the federal government to find out if there are any type of waivers or grants or any type of funding to help with kinship care dollars?
We have inquired about that, but and have not found anything that would be available to us at this point in time for any relief for federal funding.
So I would like Mr. Secretary, for the record, to reflect that we have asked if federal funding and grants are available, and they've not found any to be available. Does that mean you all have not asked? And this is for you, Secretary.
Have we asked?
Not specifically.
Yeah. I think we can ask, and we'll be happy to ask.
What is the appropriate amount of time and days that you all could be able to get an answer?
Next time we're here?
Yeah.
Next time we're here.
So we will have a follow-up at the next meeting for the Cabinet for Health and Family Services. So, Mr. Secretary, please let the record reflect that we have asked. I find it very concerning that you've said that there are no dollars available, but you've yet to ask the federal government. And I think that's a problem. A few weeks ago, I had the opportunity to go and talk to the Casey Family Foundation. And they were talking, and we talked with several people from the federal government and about the opportunities. And as a legislator who doesn't have the contact with the federal government, knows that there could be federal dollars available, I find it very interesting that the cabinet has not had that conversation, specifically when the bill requires that you all have contact with the federal government to have those conversations. I think I find it even more funny that we currently, in the administration that you all serve, there's rumor that the governor will be running for vice president. And what a fantastic opportunity to show his working relationship with the Commonwealth of Kentucky and the federal government, to how well they could work together. And so I really put it on your administration, Mr. Secretary, the administration that you work for, that if there's an opportunity for federal funding, that be shown to Kentucky when it seems like there's a direct line straight to the president's office. That's my round of questioning, and I will pass it over to Representative Klein's.
Thank you, Madam Chair. Secretary Freelander, for my own simplification and clarification, who is your immediate supervisor?
That would be, I consider that to be either Secretary Hicks, who is the Secretary of the Cabinet. That's actually who I believe it is.
And you've been around a long time, correct?
Yes, sir.
All right. Follow-up question. If you have an annual appraisal, do you have an annual appraisal, and if so, who completes it?
I do not have an annual appraisal.
Okay,
I do not have an annual appraisal.
Thanks.
Representative Wilson.
Yes, so how many more investigations do you anticipate would take place if you fully implement House Bill 271?
Just give me a second.
Is that 271?
71, it's the ongoing cases. I'm sorry, how about the investigations?
11,000.
Yeah, there it is, I'm sorry.
A little over 11,000 was our estimate.
How many of those are from Section 6 of the bill that you stated you can't, all 11,000? So that section of the bill added a mandatory investigation for when there's more than one reporting source within 30 days. And if there's a child who is a plaintiff in a DVO. Am I missing any other situation where there would be an investigation than those two scenarios?
I believe that is it in Section 6, yes.
So the estimate is 11,000 more investigations per year just based on those two scenarios?
That was our estimate.
And but these are children who are plaintiffs in a DVO, or they have a reporting source that's a professional, say a teacher, doctor. Some of these cases are already receiving investigations, correct?
Correct.
And then there's still an estimated 11,000 more children who are not receiving a social worker to their home.
That was our estimate.
When they're a plaintiff in a DVO case on an adult, 11,000 kids without a social worker coming to their home. Do you see the need for this bill?
Well, and
We don't have a policy disagreement on this bill. We have a funding disagreement.
That leads me to my next question. It's going to cost $43 million to investigate 11,000 cases. That's a high price tag. And we've not received a breakdown. We've not received anything. How do you expect us and the public to believe that?
You have a fiscal note that we provided to you.
Where is it?
It's at your budget office.
So you mentioned Senate Bill 151 is a specific program needing a specific line item. This is not specific at all.
We have an estimated cost. I don't want to put on, we have an estimated cost.
I guess I would just urge you to relook at that cost, $43 million. I think we can get it affordable. This is not a lot to ask.
Representative Wilson, I just did the math quickly on my phone, and that would be 477 additional social workers. So that's, is that accurate of what you all are asking for?
What else was that? What else was in that estimate? Was that the potential for any out-of-home care costs too? Yes.
Thank you. Representative Stalker.
Thank you. I'm really struggling here today as somebody who's just joined this committee in June, and the challenges of just, I'm going to focus on Senate Bill 151. I feel like we're all over the place here. I know we're dealing with two different bills, but just the conversation at large, I'm really struggling with here. And so I'd like to bring this back to the issue that was raised in June, which was a fiscal note. I have been in contact with your office. You and I spoke as early as this morning, and I have been trying to get in contact with other people here within LRC. So my question is not necessarily maybe directly to you at this moment, but it might be to the bill sponsor, to Senator Julie Rocky Adams, or to you, Chairwoman. From my understanding, you received a fiscal note request from LRC, and that was on February 1st. And you were asked for it to be returned by February the 8th. And on the 5th, you sent a fiscal note to LRC indicating a significant cost to the cabinet for the originally filed bill. Now, where I struggle is that I can't find that. And when I have reached out to LRC, the response that I got was that if it is not made public, if it is not on the website, then it is not made public, and that I don't have access to that. I have inquired with other members of this committee who were serving on this committee during the session in February. I went back to look at the materials from the Senate hearing, which was on February the 8th, where Senator Rocky Adams, you had sent her a letter with your original fiscal impact, and you'd requested a meeting, but I'm sorry, on the 6th, the bill was heard in Family and Children's meeting. And at the time, it was said that there was no fiscal note. So as a freshman, as somebody who's new, I have heard that there is an issue whether do you want a fiscal note to be made public or not. I am of the mind that if you have a bill and it requires a fiscal note, that should be made public to the people on that committee and to the public at large. I do not know where we go from here. As a new member, I do not know how to reckon this conversation if I don't even have access to something that was requested. And I hope that makes sense. And I say this with a great deal of respect for everybody in this room. What I also want to say, again, with a great deal of respect, and thank you for your comment, we don't have a policy disagreement. We have a funding disagreement. And the reality is, as a former foster parent with the state for 6.5 years, I have a deeper understanding, I think, than the average person probably about the challenges that you are up against and social workers. And there's a cost to this. The reality is there is a cost to this. I have had social workers in my home over the years on a rotating basis. I have seen kids that I have had the privilege to care for and it's a rotating door. Burnout is real. We cannot continue to ask the cabinet to do more with the same or less. So maybe more of a statement here, but I guess the question might be is, can we get a copy of the fiscal note that was provided to Senator Rocky Adams from your office?
I'll take that. Actually, I just got their fiscal note yesterday, and the fiscal note was dated March 27th, 2024. And I just finally got a copy yesterday. And I had to hunt for it. I had to search for it. And I finally got it yesterday. And here it is. And I'll read the fiscal note because it's kind of interesting.
Senator Rocky Adams, I am going to now place it to you.
Oh, sorry.
No, you're okay. I can't give preferential treatment, but please continue on, and you can follow up with your questions.
I'm sorry, Madam Chair, but the fiscal note it says Senate Bill 151 could, and I'm going to place an emphasis on some of this verbiage in here, could have a significant cost increase for the cabinet. Not all relative and fictive kin caregivers will choose this option. The department estimates that this choice is made approximately 50% of the time. However, the qualifying event criteria does potentially open this up to more caregivers. The department estimates a budget impact of at least $20 million, and this estimate is preliminary and subject to change if additional information is provided. I think that's kind of a key paragraph, because if you haven't figured out the parameters through the Administrative Regulations Committee, that could mean a whole lot of different things. That really changes what the estimates are. The cabinet has full authority and autonomy to design this program the way that they need to with the available funds they have. They haven't submitted the waiver to the federal government. They haven't looked at TANF dollars. the state of the Commonwealth of Virginia just passed almost the exact same bill that we did in 151, and they're funding the entire thing with TANF funds. I just talked to the delegate last week at SLC, and she told me exactly how they were doing it, all through TANF dollars. So when we're up here and we're getting frustrated, it's because you have the power to design this program to make it palatable and start to implement it, and then maybe later on we can expand it. But you could do something. If it is a priority for this administration to take care of these vulnerable kids, and Mr. Secretary, you've sat up here many times saying we need to do better with this population. We need to do better by our Kentucky kids. This is a perfect example of you having the ability to roll out a program that helps our most vulnerable. They deserve it. We owe it to them. And so if it has to start out small, so be it. But we can expand it later. But to say we have a funding issue when you return $14 million, when you lapse it back to the general fund, is absurd. And so I implore you, we stand up here ready to work with you every day on behalf of Kentucky kids. But I worry the headline tomorrow is going to be Governor Andy Beshear doesn't care about Kentucky's most vulnerable. Thank you, Madam Chairwoman.
Thank you. Senator Chambers Armstrong?
Thank you, Madam Chair. I just wanted a little more information specifically. I gather you're talking about when an adult files a protective order on behalf of a child, or a child is, sometimes minors can be named parties in different types of circumstances. Just because I thought I heard you say that that was one of the few pathways that you expected to generate 11,000 reports. Am I hearing it correctly?
That piece is always screened, and if that child is named as a victim or there are allegations specific to that child, then it would screen in and be accepted and investigated.
So the reason that I'm interested in I'd like to see the specific breakdowns in the different categories, because in my day job, I research domestic violence protective order processes in different counties, and right now I'm actually looking county by county on how many protective orders we have. And, there were 7 total domestic violence orders in Robertson County last year. There were 25 in Crittenden. There were 31 in Owsley County. Even Fayette County had 1,197. And that's total. That's including spouses. That's including people who are dating. That's including family members. And so when we only have about 1,200 in our second most populous county, and I don't have Jefferson right here in front of me, I'm just curious how we're getting to 11,000. And so I'd like to see how we're getting to those projections based on that, because I'm not sure that we had 11,000 protective orders, domestic violence orders filed in Kentucky last year. Maybe we did. But I think I'd just like to see some specificity in the projections. So if you could get me that data, that would be very helpful. Thank you.
Happy to do so.
Senator Carroll?
Thank you, Madam Chair. And Mr. Secretary, I guess just to ask in simplistic terms, if the governor comes to you with an idea on an initiative that he wants to put into place, is there a process that you follow to fund whatever that initiative is?
So thank you for that question. And I will take the opportunity to say, under this administration, we've increased the number of social workers, we've increased their salaries. We have done a lot to try to improve our systems with the General Assembly, and we have with the General Assembly. This, if someone comes, not just the governor, all sorts of folks come with great ideas around different initiatives. I'll use.
Let's stick to the governor, because we're talking legislature compared to the governor, and were the same steps followed that would have been followed if this had been the governor's request? And that's, I guess, bottom line. That's what I'm getting to.
Absolutely, yes. Is the funding there? Is it under the statutes, and has it been appropriated?
Okay. And were there funds, or are there funds that you have available to you at this time that could be used to initiate Senate Bill 151 to some capacity?
We have not found them.
Okay. Thank you, Madam Chair.
Thank you. Senator Elkins?
Thank you, Madam Chair. I'm a budget guy. It's what I've made a career doing, is reading budgets for multi-million-dollar companies. And I have requested, while we were sitting here, the fiscal note that we've talked about for Senate Bill 151. And I'm told that it is not public record and that I do not have access to it. I would love to see the breakdown, the detailed analysis of how you came to, I think it was $19.7 million to fund Senate Bill 151, or the implementation of Senate Bill 151. I'm requesting the detailed breakdown of how you determined the $19.7 million. And I'm afraid from hearing testimony, and this, I don't mean this to be offensive, I really don't, but I'm afraid that we have not just a funding problem, but maybe a priority problem. And I think these children need to be priority. I understand that we have a lot of different programs that we must fund, and I sympathize with it, I really do. But these vulnerable children have to be our priority. We can't be bickering back and forth about how we're going to fund this or how we're going to fund that. We have to find those funds, and I have a feeling that if we looked hard enough, we could find them. So I say I'm fearful that we have a priority problem. I hope I'm not correct in that. Thank you, Madam Chair.
We're going to have one last question until we bring Norma Hatfield up. So Representative Stalker, I will let you ask your question, and I'm going to ask Norma to come up. I'll ask the cabinet to step back, and then at the end we can open up with another questions if there are any. Thank you all.
Thank you, Chairwoman. My question this time is very much directly to you all. I want to make sure that I understood and heard you correctly. So you had mentioned there was about 1,200-ish kids that are currently placed with relative or fictive caregivers, right? This is the number that we're looking at to help this population with funding.
The 1,500 that I referenced are currently receiving support from the cabinet. So their children are placed in a relative fit to kin caregiver placement, and that relative fit to kin caregiver is going through the approval process to become an approved foster home.
Okay. So thank you for clarifying that number. So it's closer to 1,500. Am I correct in assuming that these children, that the individuals that are in the process of this, that these children, there was an intervention by DCBS to say this child's safety is at risk, and then prior or before, rather than these children going into foster care, you were able to identify a family member, fictive, or kin, that was willing to take these children, correct?
I'll try, but I will ask for clarification from Commissioner Dennis, and you're going to hear this from Norma. Folks come in, we find where we are removing a child. We find where a child is going to be removed. We ask that fictive family within a fairly limited time frame to make a decision about which way they're going to go, towards adoption, towards coming into foster care, or not. Those are three different decisions, and we ask them to make them quickly. We agree. Too quickly, we should be giving more time, but when you allow somebody to make a different decision in a time frame, that's more money, that's more funding that would come from DCBS to do that. And that's why we estimate, part of why we estimate that there is a cost to that.
And just let me clarify, the 1,400 to 1,500 I referenced, these are children that are in DCBS custody, but we have placed them with a relative fit to kin caregiver who is either already a foster home or they're pursuing to become a foster home.
Okay. So there's a part 2 to this question, but thank you for clarifying that part, because I think that's important to this next question that I'm going to ask for greater understanding, which is, would this program be available to individuals who never had an intersection with DCBS. So what I mean, for example, I work great with examples. If I am Aunt Sarah and I am recognizing that a sibling of mine, a family member of mine, is struggling with drug addiction, or that there's some suspected abuse, and I personally, outside of the system, because maybe I don't want to bring the system into my household, and I say, you know what, I'm going to take my nieces because it looks like you need to go to rehab, to my sibling, and I take custody of those kids temporarily or for however long amount of time. Would individuals, because I think it's important for this room to understand when we talk about numbers of like where kids are, those are only numbers we have because they're reported on because somebody specifically interacted with you. But and because you interacted with their family. Typically, if I am an aunt who is taking on to nieces of mine because I have a sibling who's dealing with drug addiction, I'm not going to come to the cabinet and say, hey, FYI, just wanted to make sure you knew I've got these two kiddos there with me, right? Maybe unless I'm looking for help. So I just say that because there's a whole other population of families and children who have not intersected formally with DCBS. And what I want to understand is, would those individuals be able to come to you and say, you never showed up to my sister's house to see that she was struggling with drug addiction and that the kids were being neglected, but I did, and I've had these kids now for 6 months. Can I be part of this program? Could I receive funding? Do we know the answer to that question?
I don't think it's black and white. It depends on then if they went back to the courts to get, I think. By the way, I'm not a doctor and I'm not a lawyer, just to be clear for everybody. So I'm not practicing. But I think if the courts then got involved, then that would be a possible avenue.
Possible, but I think my understanding of the intent was that they would have had prior DCBS involvement.
Okay. Thank you for your answer. I just want to bring that to the forefront in case this is a road that we find ourselves traveling down so that we can anticipate that. But also just to, I think, to reiterate the point that you were making is you're giving us estimates based off of a response to a population of people that you're like, I don't know if these people are going to want to get us involved and go through this process, or if people would rather just stay out of the system altogether and say, we'll figure it out on our own. So I understand the challenges that you have in trying to give estimates, because we are asking you to have a crystal ball at some point and make predictions as to how many of these families do or do not want the partnership, the intervention, the support, right, from the cabinet. Thank you.
Okay, I'll ask that you all step aside so Norma can come up. Norma Hatfield is with the Kinship Families Coalition of Kentucky. And then Norma, when you get settled, if you will introduce yourself for the record, please make sure that the green light is on your microphone.
I'm Norma Hatfield. I am a grandmother raising 2 grandkids for the past 10 years. I'm with the Kinship Coalition of Kentucky, and I'm also with Generations United Grand Voice Network. I'm going to skip some of the slides that we have here, so bear with me. I wanted to hit some points based on the conversation that has happened and share a little bit more insight into why I think we can be doing more on Senate Bill 151. Try to do something wrong with the slides. Okay. Thank you. So now just arrow down. Okay. Left to right. Left to right. Okay, I'm going to skip this slide. Some of these are basics as far as the different types of kinship care that are out there. And what I'm going to do is I'm going to focus specifically on what we're talking about with Senate Bill 151. I broke this into 2 sections. This is not how it's laid out in the bill. The first part is that it gives a child a voice. A social worker should be asking a child, who do you want to be placed with? And I can tell you that had this happened to my grandchildren 10 years ago, they would have said that they were going to be placed with my husband and myself, and they would not have gone to traditional foster care because we never got a phone call. I understand that Senator Rocky Adams also had conversations with other youth, and they said the same thing. It's really hard when you are in the system and you're experiencing it yourself. As a caregiver, and I can't even imagine what it's like as a child, you feel voiceless, you feel powerless, you feel like you have absolutely no control over what is about to happen to you. And giving that voice is extremely important. The second part that we're going to talk about in regards to this bill is the 120 days that we've been talking about, that flexible placement option. I'm going to share just a little bit, if we have the time, in regards to the form and take you through a little bit of that scenario and what's happening and why we need Senate Bill 151. The other part of it that we've talked about here today is around the life qualifying events. That's the part that probably is going to cost a little more money, and we need to look at how that's going to be implemented. The life qualifying events are things such as, you make the decision, let's say you're beyond the 120 days. Let's say it's a 125 day. And all of a sudden, a 2-income home, somebody has to give up their job, or they lose their job because the sibling groups have too many demands that they didn't know on day 1 or day 120. A lot of children that are born addicted to substances require 24/7 care. And when you fill out that form and you make that choice, you don't know what you don't know. You don't know what life is going to look like in 5 days, 10 days, 30 days, or more. And we really need to make sure that we get these choices in place in the correct way for folks. So life qualifying events, going back to that, is I lose my job, my income changed. I need to look at better options for the child. I lose a spouse. I lost a huge support structure, and I need to rely on some of the support structure that comes in line with relative foster care. So that's kind of the components of the bill that we're talking about. I'm up here for one reason and one reason only. It's not political. I'm not a politician, don't want to be ever. I am here because I want to see things like this for kinship families in the future. I do not benefit from this. My family does not qualify for this, and I'm okay with that. But I see something really wrong with how services are being offered. It affects the kids in the long run. Those services were intended for them, and that's what needs to be changed. Now, I think this is important to see a little bit of this timeline. This is more my perspective and what I saw going on, but it goes into a little bit more of when we talk about recommendations and how to implement the bill. So bear with me really quickly. I did an op-ed around November 30th, and depending on the publication, it was out there even through the first week of December. And it was 5 things we can do for kinship families. And one of the things that was in there was around the flexible placement option that's in Senate Bill 151. I then had a meeting with DCBS. The purple boxes that are there are all meetings that I had with DCBS while this bill was in progress. DCBS, it was Commissioner Lisa Dennis. She had some of her other staff. Later on, the AOC, Administrative Office of the Courts, were also in attendance, and off and on, there were folks from Kentucky Youth Advocates as well. So I had that meeting on December 15th, trying to be above board, trying to figure out how we can make some policy changes without legislation, or try to do both, but try to get everybody to work together. Then I had a meeting on January 8th with Senator Rocky Adams, and I shared with her that same list of things that we needed to do. Now, you'll look on that timeline, all the green. She quickly ran with that bill, and it got all the way through to the governor's signature, which was on April 5th. I had another meeting I went to the Senate and Families and Children's Committee meeting on February 8th with Senator Rocky Adams, shared stories of caregivers, the importance of this bill, and I had no idea that there was some memo out there that was also dated around February 8th that said this is going to cost $20 million. I have a meeting with DCBS on February 9th. I still don't know that there's a problem. In the meetings with DCBS, we are talking about how is this process flow going to work? we're looking at how do we maintain federal dollars, which, by the way, in your packet, it's roughly 72 cents on the dollar are federal dollars that are out there. We're trying to be good stewards, and we're trying to make sure that things are in the right place so that as this bill goes along, we're really all in agreement on the changes that need to happen for these kinship families. I meet with DCBS and the AOC also on February 9th, as I mentioned. And the other thing that comes out of it that I wanted to make sure you knew was, as we're talking about this process flow, somebody in the AOC says, you know what? Because nobody knows that date, that milestone that's out there when the federal dollars are not available anymore. We're trying to figure that out. The cabinet's going to go look at it. But something that the person says in the AOC, they said, you know what? I think this is a paper drill. I'm paraphrasing slightly. I think we can just do a judge's amended order, and the child can still stay with the caregiver, and the federal dollars hopefully are still there, and it's just a matter of changing that status with the judge. The cabinet, from my understanding, is going to go back. They're going to explore this, get their Title IV-E federal dollar folks, and they're going to go figure this out. I have another meeting with DCBS on March 15th. In the interim, between the 15th to the hearing on the 19th of June, I am texting folks in DCBS, and I'm asking in email, where's the regulation? We'd like to look at what's going on in the draft regulation to provide some input. Don't want to miss that. So on June 19th, I come to the hearing just by accident. I say accident in regards to this bill. My granddaughter's actually sharing some of her story, so I'm here. And then the question gets asked, what's going on with SB 151? And I'm totally shocked that the answer is, we're going to do nothing. To me, that's just totally unacceptable. Because I've been having conversations with DCBS, working through a lot of these processes, and I'm expecting more than that, and there's nothing there. Now, placement options, temporary custody, this is when we're looking at the 120 days when a caregiver gets that form, and the other one is kinship foster care. And it's important that we get this right, because just recently, and one of the things that was in my op-ed was the need for a guardianship assistance program, which the legislature approved, the governor approved in the budget, the cabinet lobbied for. We've been asking for this for years. It's subsidized permanent custody. So a kinship caregiver, if they meet the requirements, which is roughly 6 months of a child being in kinship care, kinship foster care, then they would then roll into the subsidized permanent custody. What that does is that provides additional resources and subsidies for that child after the case is closed, when there's no reunification for the parent, and they receive additional assistance till the child becomes an adult. This is a game changer. It is important that we get this election, the flexible option for placement correct, because more and more children are going to be having on their behalf services waived that they're going to need in their lifetime. I was going to share with you a little bit about the caregivers and why we need this option, and I know we don't have a lot of time. But just imagine you get a phone call, or your grandmother gets a phone call to go to the hospital. You don't know exactly what's going on, but you know that it's something to do with your grandchild. We talk about abuse and neglect, and I think sometimes it's easy to skim over what that really means. You may walk into the hospital, you may see a child that's 6 years old that is hooked up to all kinds of tubes or a ventilator or anything. You might see that they've been deprived from food. You might find bruises on their bodies. You might hear the words molestation. You may hear all of those types of things. You might find, as a grandfather told me, he sat in a NICU for 29 days, and he said, don't talk to me about anything else except that particular child and what I need to make sure happens for that child. That is not the time that you give somebody some legal form that's got some link to some video out there and all the terminology which, by the way, after 18 months in the system with my kiddos, I didn't still even understand. It is not the time. We do not let people who do not have all their faculties to make decisions get in a car. Why in the heck, knowing that this is services for these kids potentially till they're an adult, why in the heck would we allow this to happen in a moment? I am in, as a caregiver, fight or flight in those moments. And it takes a while to come down from that. And like I said, I don't know what life is like in an hour, 5 hours, 5 days, 5 months. And I get in what you might think of as mama bear mode. I am focused on that child and only that child. And what is happening is that caregivers, when they get that form, they hear, you can have the child in temporary custody right now, or you can pursue DCBS foster care. Well, most of them that have come to me, and there have been hundreds over the past 5 years, they have come to me and they said, had I known later more details, I would have taken relative foster care. This is wrong. And that's why we need Senate Bill 151. This is the form. It's an excerpt. It's not complete, so I don't want to mislead anybody, but there's the 3 choices. A caregiver has a custody arrangement already with DCBS. A caregiver chooses to seek temporary custody, and a caregiver chooses to seek approval as a DCBS foster parent. And you're going to tell me you're sitting in a hospital, you're going to sit down and watch a video. And oh, by the way, there's no timestamp on this. None. But it says in there that you can seek legal counsel. When are you going to do that? You're going to walk away from that grandchild that's on a ventilator or something and say, oh, I need to call my attorney and they're going to run right over here? Or I could potentially lose the kids? I don't think so. You're going to check what's going to guarantee that you have that child with you and they are safe and they are secure. Doing what's best for the kids is SB 151. I talked about a timestamp just a moment ago. A grandfather reached out to me. I did an ombudsman complaint for him a few years ago. He actually told the social worker, I need time to talk to my attorney. I do not ever sign these kinds of forms without talking to an attorney. The social worker agreed. He made an appointment. He shared those arrangements. Let's say it was 2 o'clock the next day. He had the kids with them. They were safe and sound. He had made arrangements to, after he saw the attorney, to go back to the social worker. And guess what happened? While the kids were in school that day, when he was supposed to go see the attorney, they were pulled out and they were put in traditional foster care. I don't know what happened there. I don't know if somebody looked at the file and panicked because there was no form at all and the kids were technically in custody of the cabinet. I don't know. But this is not working. And that affected, he shared with me, the 16-year-old who then had even more trust issues out there. This is not the right thing for the kiddos. Recommendations on 151. We need to immediately, today, not tomorrow, not in another meeting in another 30 days, right now, and I know we can, we need to implement the 120-day option on the placement. And I say that because under federal law, a child may live with kin in temporary custody up to 6 months before losing federal funds for that placement. I do some consulting with a lot of national child welfare organizations, and after June 19th, when I felt like somebody wasn't looking at Title IV-E, so I probably need to start calling some people that I know that would know a little bit more about it. And I've been scrambling right up until yesterday to really understand this. And guess what? The Administration for Children and Families website, 8.3a.11, Title IV-E foster care maintenance payments, goes on because other states have been asking these questions. The statute allows a 6-month period of time during which the child can live with an interim caretaker, relative or non-relative, and still be eligible for Title IV-E. Under prior policy, we interpreted the term removal to mean a physical removal. As a result, if the interim caretaker was a relative and the Title IV-E agency intended to remove custody from the parent, but let the child remain with the interim caretaker or relative, the child could not be eligible for Title IV-E funding because the child was not physically removed from the home. The policy created a disincentive for relative placements. To remove this inequity between the relative and non-relative caregivers, we now permit the removal of the child from the home in this circumstance to be considered a constructive, non-physical paper and legal removal. That allows those federal dollars to stay in place. So if you go back to that estimate that I saw when I did an open records request on February 8th that said that every bit of that back to 2017 is general funds, guess what? Not so much today. We have a lot of options here. You go back to that form you just saw. A social worker, and I swear, I do not believe this would cost $20 million. A social worker could probably, knowing this, right in the corner of that form, you have 120 days from the date of the signature to consider all your options. That doesn't cost $20 million right there. And we don't have to wait on new forms. We can do this, and we can do it right now. We also need to put some more monitoring on looking at the statistics and the reports that are done every year on kinship care, because I think that more than half the kids that are in temporary custody instead of kinship care, and knowing the hundreds of families that have said, I would have chosen something different had I been giving a better opportunity and more communication, we need to see those numbers go up. We need to understand that not everybody will make this option, but that we need to make sure that it is getting better and we're doing our part. Communication needs to improve. The form needs to change. We need to get more information out there. This is not all the social workers' fault, by the way. There are communication problems, and it's been this way for years, between their headquarters in Frankfurt to their regional offices to the social worker in the field. And they do the best that they can. I honestly believe that. But we got to put things in place to get this right. We need to look at maybe a working group for the life qualifying event piece, as Senator Rocky Adams talked about earlier. That can be set in regulation. That can be done a little bit over time. But I think that we can implement a lot of this bill right now, today, and we should be. Think about the families that are sitting out there that we now know could have these options in that 6-month window, and we're not doing anything. That's a lawsuit. Not only are you depriving the kids, but the state's going to end up pulling money from some other program for the lawsuit because we didn't do this right. We need to also research and utilize all funding sources such
Norma,
as TANF.
I am so sorry. I'm going to interrupt. Thank you for this wonderful presentation. We have about 7 minutes before I think that we need to clear the room. I think that our members do have the PowerPoint presentation in their packet, and they can see the recommendations on here. For the next 7 minutes, I do want to allow time for questions if anyone does have questions, but I do want to take the time just to thank you, Norma. I know you've worked diligently on this and talking with DCBS and the federal government and with legislators as well. Do any members have any questions? Representative Fleming?
Thank you, Madam Chair. Madam Chair, I just had a question for the Secretary, if you wouldn't mind scooting up here up front. I would appreciate it.
While we wait, does anyone have any questions for Ms. Hatfield? Okay.
Can I leave? Should I leave or stay?
Thank you, Mr. Secretary. I thank you and others. We've gone through and made a point about the word, an operative word called priorities. And I want to see, could you go through with me and give me your assessment on how you make priorities by using different weights to come up with a score to see exactly how that meshes with the overall objective and mission of the state in order to provide services to our citizens? You understand me? You look, I have a little frown on your face. I'm
not sure I understand the question. I'm sorry.
So I'll give you an example. So in my business, I go through and I look at different programs and services by doing that. And I have a priority. I go through, and I hate to get geeky on it, but I do a linear programming problem. And basically I have various components and I put weights to those components. And those weights are somewhat subjective, but then again, I do that. And that basically goes through a calculation that gives me a score of 45. Or go through another program, gives me a score of 65. Then I have to look at my customers, what they want. In your case, children being abused. That's a pretty high priority, and that is a high priority. How does that compare to other programs within your cabinet in order to go through those processes, in order to look at these fundings? You can shift money, from other programs that may or may not be codified over to what you think and what we're hearing from the constituents of what's really significant in terms of funneling money to that. Does that clarify that?
It does, but the question you've asked is how we prioritize programs, this being a specific program. Most times, it is, do we have funding to implement the program? And in this case, we do not.
Okay, and I appreciate that, but it seems to me that there's been statements that there are some programs that weren't codified, but that were funded. And I know each department, each cabinet has, at least my understanding, they have some type of discretion on this funding. So going through that linear programming process, if you recognize you don't have funding, but you know it's a high priority, why wouldn't we shift monies around in order to do that? Because you can do that within your cabinet, I understand, for the most part.
There is some limited authority within the cabinet to do that.
Right.
I do not have a linear process where I can show you the weights to how that decision is made.
Okay. So, and I respect that. So how do you look at all these programs and determine the emphasis and the priority of that if you don't have that type of infrastructure to support your decisions? In other words, and I don't mean you're saying this, but say you throw in spaghetti against the wall, or you said, oh, this feels like it should be we should do that, or something like that. Or is it more data-driven, evidence-based type of a process?
I aspire to data-driven decisions. It is challenging within the context of CHFS as a big organization. It is usually then within the context of the funding streams that those decisions are made. There is some allowance in the budget for the secretary to shift dollars, but that is not one that is utilized except in times of pretty extreme budget issues. That's the time I've seen secretaries do that. 2008, 2009 would be examples of when that occurred. So that's usually when that particular portion of the ability to shift those funds is done. Does that make sense?
It may. Yes, I understand.
Okay.
But it's not. I think I've got my answer.
Okay.
Anyway, but I appreciate it. Thank you, Madam Chair.
Thank you. And the last chair will be for Senator Webb.
Thank you. And those of us who have practiced against and with the cabinet for the last 30-some years and still do, and I fought with them like everybody else and asked them to actually put me in jail a time or two for defending my clients. But they have existing obligations. They have existing programs that we all know that they're shorthanded with fulfilling existing caseloads. With the demographic that's come post-COVID with our increase, in some regions more than others. I'm in a rural area, and we don't have the services that they do in the urban areas. Our social services are strapped just doing what we have mandated them to do now. Now, I've always been a proponent of placing those kids, never met a kid that really didn't want to go home most of the time, but placing them with a relative. But then again, I'm a realist, I practice law, and you also see children who would take the path of least resistance, whether it's in domestic court or in this choice. So the role of the cabinet is very important, and the investigation, even if they're placing with a relative, and usually the conditions and the environment where they have come from, or their family, their parents have come from, is more important than ever to make a more permanent decision than temporary custody, to me as a practitioner looking out for that child. So the role of the cabinet, we cannot undermine the role of the cabinet enough and the resources that they need to do this for the sake of the child and do it correctly. Because not every home is suited for this. We need to look at, in my budget experience, how the federal dollars come down, how they interface with a shift of program, and how we could phase that, how federal dollars impact the existing bottom line. Then with the shift, what gaps that we would have. Those are the questions that I'm looking at from a comparative interface standpoint with federal law. The courts that I go in, most time, the judges are saying, we're hamstringed by federal law on this, on that, on placement, on time frames. So that's the questions that I would like to resolve first, and then see if our budgets could create a shift or an incremental shift or a phasing in of the importance of Senate Bill 151. And these things will take time, and they will